네, 안녕하세요. 카플라 TV 시청자 여러분. 제 이름은 제임스 안유고요. 오늘은 7월 15일 목요일 오후 5시 25분입니다. 오늘 영상은 어저께 Mental Health Advocacy Services라는 비영리 단체랑 이제 저희가 이제 파트너십을 이제 맺으려고 해요. 저희 LA 한인회랑. 얘네들이 뭐 하는 비영리 단체냐면 핸디캡, 그러니까 뭐라 그러죠? 디세빌리티 있으신 분들을 위해서 이제 세입자 권리를 이제 싸워주는 뭐 이런 단체입니다. 그래서 이분들이 지금 코비드 19인에서 나오는 정부 지원금, 또 요번에 뭐 9월 30일까지 이제 익스텐션이 됐잖아요. 렌트 태거 명령이. 그래서 이거에 대해서 이제 저희가 앞으로 한국어로 진행되는 웨비너 시리즈를 여러분한테 이제 프레젠트를 하려고 준비를 하고 있습니다. 근데 그걸 하기 전에 제가 한번 니네들 다음에 이제 사람들한테 해주는 웨비너를 내가 좀 참석을 했으면 좋겠다 해가지고 어저께 참석을 해서 영어로 이제 들었습니다. 근데 어쨌든 제가 이제 지금 보여드리려고 그러는 영상이 영어로 100% 돼 있는데, 일단은 많은 분들이 궁금해 하시고 지금 급하신 분들이 많으시니까 일단 제가 요거는 서브타이틀 캡션 없이 그냥 여러분한테 그대로 영어로 제가 보여드릴게요. 근데 다음 주나 다다음 주에 저희가 이제 한국어 통역 하는 분을 이제 모시고 이거를 이제 우리 LA 한인회한테만 이제 프레젠트, 그리고 우리 LA 한인회 멤버들 여러분들한테만 보여주는 그런 영상이 이제 준비가 될 겁니다. 어쨌든 그거를 해드리기 전에 오늘 뉴스가 나왔습니다. 조금 아까 나왔는데 조금 아까가 아니죠. 한 점심때쯤 나왔는데 LA 카운티에서 이번 주 토요일 날부터 안에 계셔도 마스크를 쓰고 이제 다시 다니셔야 된다는 뉴스가 나왔습니다. 그래서 이번 주 토요일 날, 그러니까 이번 주 금요일 날 밤 11시 59분이니까 이제 토요일 날부터 안에 계신 분들도 백신을 맞으셨어도 식사할 때 빼고는 마스크를 쓰셔야 됩니다. 오케이. 왜냐면 지금 LA 카운티 보건국 웹사이트에 가시면 지금 계속 이 숫자가 올라가고 있습니다. Everyday 이 인펙션 레이트가 계속 올라가고 있어요. 그래서 조금 델타 베리언트 때문에 지금 감염 숫자가 지금 계속 올라가고 있습니다. 여러분을 겁을 드리려고 그러는 게 아니고 이거는 지금 팩트입니다. 그래서 지금 마스크 계속 착용하고 다니시고요. 토요일 날서부터는 안에 계시는 분들도 마스크를 쓰고 다니셔야 됩니다. 오케이. 영상 보시고 혹시 궁금한 점이 있으시면 댓글창에다가 질문을 해주시면 제가 뭐 대답할 수 있는 건 제가 대답해드리고, 아까 말씀드린 것처럼 다음 주나 다다음 주에 한국어 통역을 써서 이런 비슷한 웨비너를 여러분들한테 이제 프레젠트를 할 겁니다. 그래서 네, 한번 보시죠.
And just so everyone knows, we do have closed captioning enabled for this. It is the automatic translation, so it might not be perfect because it's not an actual person transcribing, but we will try and speak clearly. Charles, thank you for introducing yourself in the chat. If other folks want to do that, please go ahead. So if you are interested in getting closed captioning for this, there should be a button at the bottom of your screen next to, record and share and all of the reactions and stuff that you can click on, and that'll give you an option to access the closed captioning for the presentation. We'll give it just about one more minute and then we will get started. Thanks to everyone introducing themselves in the chat. Great to see everybody. All right, it looks like the number of people entering the waiting room has slowed down. Hi everybody, thank you so much for joining us today. My name is Kate Bridle. I'm a staff attorney at Mental Health Advocacy Services. I am here with my colleague Alana Lohr-Schmidt, who is a senior attorney at our office. And we are going to be talking about COVID-19 eviction protections, and then also about fair housing protections that are in place with a focus on fair housing protections for folks with disabilities. Just so you know, you will be getting the PowerPoints, so don't feel like you have to take notes on every single thing that's said or that's on the slides, because you will get a copy of the slides after the presentation so that you can have those for reference. If you have questions, feel free to pop them in the chat. While I'm presenting, Alana will monitor the chat a little bit and possibly answer what she can, and otherwise bring the rest of the questions to me after. Obviously, we have a limited time. We have an hour or so, and it's a lot of information. Yes, Mickey, the PowerPoint will be emailed out after. It hasn't been yet. So yeah, feel free to pop questions in the chat. We can do some questions in between. We might just have to limit some of them. We can't answer questions if you have a case specific to you, if you're dealing with a specific issue. We can't really give legal advice in this format, but we'll give you our information to reach out to us after the presentation as well. But we can take some general questions about the information. So I'm going to talk first about COVID-19 eviction protections, and then I will let Alana take over after that point for the fair housing portion. We do also have a quick poll at the end for the fair housing presentation. It helps us assess how we're doing, how you're learning, whether we're teaching effectively. So if you can take the time to fill that out when we launch it at the end, we'd really, really appreciate it. All right, so without further ado, I will share my screen and we will get going with all of this information to give you. Oh, my cat has decided to start ripping up a paper ball in the background, the joys of working from home. So my apologies if there's a loud ripping noise. Okay. So, as I said, I'm going to be discussing the tenancy protections that are in place currently, specifically in place due to COVID-19. But first, I want to tell you a little bit about us as an organization. So we are a nonprofit legal aid organization. We are based in Los Angeles. We provide free legal services to low-income folks with mental health disabilities. And our mission is to protect and advance the legal rights of low-income adults and children with mental health disabilities and empower them to assert those rights in order to maximize autonomy, achieve equity, and secure the resources that they need to thrive. So we were founded in 1977. We serve all of Los Angeles County. Our physical office, which we haven't been to in a while, is in Koreatown. We're not in the office at the moment, but hoping to ease back into it, who knows, fairly soon. We do a lot of different things. Obviously, we do fair housing work. We also help folks with the barriers to getting their benefits, employment barriers, homelessness prevention, some special education stuff. So we cover a wide array of things, but today, obviously, we're focusing on housing. So here are some of the topics that I'm going to be discussing. So I'm going to talk about rent increases during COVID, the different levels of eviction protections that are in place, what happens to rental debt that's accumulated due to COVID, and then some of the rental assistance programs that are out there, which really at this moment is just one. So first off, rent increases during COVID. So there are the state of California has some laws in place that limit rent increases. And then locally, there are also some laws in place that completely prohibit rent increases. And I'm going to be focused on the city and county of LA in this presentation because that's where we're based. I recognize there might be some folks from other areas of the state. And I will try to acknowledge, when there are other areas that have these similar protections, to just look in your local protections as well. So state of California, as I said, limits rent increases. So one of those statutes is actually in the penal code. It's a price gouging statute that prohibits price gouging during states of emergency. So as long as California is in a state of emergency, landlords are not allowed to raise the rent. That's supposed to say 10%, just caught a typo. Sorry about that. Not 20%, 10%. I'll correct that before we send the slides. The no rent increases of 10%, more than 10% during the state of emergency. And the big thing about that is that it applies to new tenants even after a tenancy turns over. So it's not just for tenants whose current landlord is raising the rent on their current unit. It's also if you get a new unit, the landlord can't charge you more than 10% of what they charged the previous tenant. We also have the Tenant Protection Act in California. This is in place all the time, not just due to state of emergency. It only applies to certain properties, which are apartments that are over 15 years old, single family homes or condos that are owned by corporations, and then duplexes that are not occupied by the owner. And so for those units, all the time, there is no rent increase above 5% plus whatever the change in the cost of living is for that year. So this year, I believe it's around 3%. So roughly 8% is the cap right now. So for these specific units in the state of California, landlords cannot raise the rent more than about 8%. As I said, there are some localities, the city and county of LA both prohibit rent increases completely on rent stabilized units during the state of emergency. So for the county's prohibition, it only applies to the county's rent stabilized units. So the city and county each have different rent stabilization ordinances that apply to different buildings. Gets confusing. The county's applies to buildings with 2 or more units built before February 1st, 1995. So there are no rent increases currently for those units. And the city's applies to buildings with 2 or more units built before October 1st, 1978. So no rent increases at all for those units in the city of LA during the state of emergency. So there are also eviction protections in place due to the COVID-19 emergency. These are called just cause eviction protections. So normally only the properties protected by that Tenant Protection Act that I mentioned in the last slide get these protections. But right now, AB 832, which is the COVID eviction protection bill that was just recently passed, extends these protections to everyone in the state of California. So all tenants in California currently have these protections until the end of September. What that means is normally a landlord can terminate at the end of your lease for no reason. They can say they just don't feel like renewing it, what have you, or for a number of reasons. Right now, they are limited in the reasons that they can give you for evicting you, and they cannot do it for no reason. They have to have a just cause reason. And there are 2 types of just cause evictions. There are at fault just cause evictions, which is what they sound like. The tenant did something to be at fault. They broke the lease, they're damaging the property, stuff like that. In those cases, though, the tenant still needs to get a notice and an opportunity to cure whatever the problem is. So they can't just be kicked out. They have to get an opportunity to fix the problem. And then there are no fault just cause evictions, which is, again, what it sounds like. The tenant didn't do anything wrong, but the owner is evicting them for something that's not their fault. So maybe the owner has a family member that they need to move into that unit, or the owner wants to move into that unit themselves. The owner is getting out of the rental business altogether and they're selling the whole building and they're evicting everyone. Those are no fault just cause reasons. And there are only specific ones of them that landlords can use. So right now, those are the only reasons that tenants can be evicted in California. The other big thing is that if your landlord is trying to evict you for something that's other than non-payment of rent, so you didn't pay your rent, but your landlord's evicting you for being a nuisance, your landlord can't go after that rental debt unless if you did everything that you need to protect yourself under the COVID-19 eviction protections, which I'm going to discuss in just a minute, how to protect yourself under those. So what was happening is landlords were trying to evict people for not paying their rent. These protections kicked in and people were exercising their rights and saying, I can't pay due to COVID, I am protected from eviction for non-payment. And then landlords were turning around and saying, oh, well, now that person's a nuisance. They're a peeping Tom, they're bothering the neighbors, things like that. And then trying to also get their money back. So we're trying to prevent those evictions that are really for non-payment and trying to discourage that behavior in landlords. So I just mentioned that in order to be protected from that, you need to do some certain things under the COVID-19 eviction protections. So what do you do to be protected from non-payment evictions during COVID-19? So the first thing is your landlord has to serve you a 15-day notice to pay or quit if you haven't paid your rent. And that notice has to include a copy of this declaration of COVID-19 related financial distress for you to sign and return. You cannot get a notice for less than 15 days until the end of September. No notices for less than 15 days for non-payment cases. There are still 3-day notices allowable for other types. But for non-payment, nothing less than 15 days, and they always have to include this declaration. If they don't, it's not valid. In order to protect themselves, tenants should sign and return that declaration within the 15 days they have on that notice. And then there are two different time periods that are significant. So if you owe rent from March 1st of 2020 to August 31st of 2020, you only need to return one declaration for that entire time period. And then you cannot be evicted for the rent you did not pay during that time period. The rent doesn't just go away, unfortunately. There's no rent forgiveness as of right now. The landlord can still sue to collect that unpaid rent in small claims court, but not until November. And then for rent due between September 2020 and September 30th, 2021, you need to return a new declaration every time you get a notice from the landlord. And your landlord might not serve you notice every month. Some landlords, you don't pay September, November, December, and they will do just one notice at the end of December for those 3 months. That's fine, but every time you get a notice, you need to return that declaration within that time period. And then the additional requirement for this time from September to September is you need to pay 25% of the total rent due for that time period by the end of September. And that does not mean that you have to pay 25% of your rent every single month. Some landlords are trying to tell tenants that they've got to pay 25% of the rent every month. That's not true. Just 25% of that total rent due for that time period. It can be a lump sum payment on September 30th if that's what works for you, and you will be protected. And then again, that 75% that remains doesn't go away. The landlords can go after it, but not until November 1st. So what happens if you miss that deadline? So you don't get that declaration returned to your landlord in the 15 days. It is not the end of the world. So you can still file a declaration with the court within the time that you have to file an answer. So what happens is you don't get the declaration back. Your landlord's going to file the eviction in court. The court's going to issue you paperwork that's a summons, and that gives you 5 days to answer that summons. You should always answer, file something in court. You can amend it later, but always file something in that 5 days, because if you don't file an answer, a landlord can get a default judgment and win automatically. So it's important to file something, but you can also file that declaration within that time period. The court won't automatically accept it, but they will hold a hearing to determine if you missed that deadline for a good reason. And the big thing here, since we deal with a lot of tenants and clients with disabilities, disabled tenants are entitled to request reasonable accommodations at any point during the trial. And Alana's gonna go into more detail about what reasonable accommodations are and how they work. But basically you're asking for an accommodation because of your disability. So if you have someone, or you know someone, or you are someone who missed these deadlines, even that second 5-day deadline, due to a disability, say you have a mental health disability that comes with memory loss, or have memory issues and you didn't remember the deadline, or you have some other disability that you have trouble meeting deadlines, you can ask for a reasonable accommodation to still file that declaration, and the court, it's very possible the court will allow you to do that. So if you have disabilities that affect your ability to get this stuff in a timely manner, ask for a reasonable accommodation. So I've talked a lot about small claims court and the fact that landlords are going to get to pursue this money there after November 1st. So I want to talk a little bit about how that process works. So as I said, landlords can't bring it until November 1st of 2021 as of right now. After that, once they're able to start filing, the process is really fast. So court dates get scheduled within 3 months, and then the hearings are only 10 to 20 minutes, and then the decisions come within 2 weeks. There are no lawyers in small claims court, which means that tenants can't have lawyers there, but neither can landlords. There are lots of places that will help tenants prepare, including us, for these small claims proceedings, help make sure you have all of your paperwork together, have all the evidence you need. A lot of legal aid organizations are going to be doing that work for tenants facing these claims. So please feel free to reach out and get help preparing. You don't have to go into it completely blind. There's also no jury, so it's just a judge, and that judge is able to reduce the tenant's debt if the landlord didn't accept rental assistance. So if your landlord refused to cooperate with rental assistance, then the judge could say, well, you could have gotten all of that rent back, so the tenant doesn't have to pay you that amount. There are also a lot of new requirements for landlords even to file evictions or to get granted a summons. So if the landlord can't show that they tried in good faith to get rental assistance for the tenant, then the court will not even issue a summons or allow that eviction to go forward. So landlords are going to have to start demonstrating that they tried to get rental assistance. The other big thing is these actions are masked, which means that they don't show up on your records. The debt itself is still going to show up. The fact that you owe a certain amount of rental debt will show up on credit reports and public records, but the fact that someone took you to court over it won't, which can be really big for finding new housing and things like that. Eviction proceedings for non-payment evictions filed between, I believe it's March 4th of 2020 and then now September 30th of 2021 are also all masked. So they can't show up on your record that you had an eviction filed against you either for non-payment. Ask for an interpreter if you need one. And then the other big thing is that if you don't want to go to court, you don't want to go to small claims court and your landlord might be willing to work with you, LA County does offer free counseling and mediation, so you might be able to contact them and work something out with your landlord. All right, so I want to quickly mention the CDC order. It is unfortunately expiring at the end of this month, and the CDC has said that they don't anticipate extending it again, but for the next couple of weeks, it's still in place and can still protect people. This applies nationally, and the big thing about the CDC order is that it protects against non-payment evictions, even if your non-payment isn't related to COVID. So for the state eviction protections and the local ones too, you have to show that you've had some sort of COVID-19 related financial distress. But for CDC, you don't need that. So you can just, if you couldn't pay your rent before and you can't pay it now and it's not because of COVID, you can use this to protect yourself. It requires submitting a declaration that's similar to the state one, but there's no time limit for when you have to submit that. And as I said, it's just through the end of July, but might be able to use it for someone to protect them in that time period. I do want to mention that there are lots of ways to tie your financial distress to COVID. I mean, even if you didn't lose your job due to COVID or your income wasn't impacted, say you're on benefits, if you've been helping a family member who did lose their job, if you normally would have been looking for a roommate, but you haven't been able to find one to help you pay your rent because of COVID. There are all sorts of ways to tie in COVID-19 to how you've been financially impacted. So I encourage you to contact legal aid organizations to see maybe if they can figure out a way to tie it so that you can be protected as well. And so now I just want to mention local eviction protections. The city and county of LA both have eviction protections in place. They're very, very similar. The big differences are when they end. So the county's is currently only through the end of September. The city's is tied to the end of the local emergency in the city of LA. So it'll be in place until LA says there's no longer a state of emergency. In both the city and county of LA, those no-fault evictions that I talked about are banned. So in the city and county of Los Angeles, you can only be evicted for an at-fault just cause reason, which means you have been doing something, you've been violating the lease, something like that. You also can't be evicted in the city and county for having unauthorized occupants or pets or for causing a nuisance if it was due to COVID-19. So if your mom needed to move in with you because she maybe got sick or she lost her job due to COVID, she needed to stay with you for a little while and she's not on the lease, can't be evicted for having her there. Mom brings her dog, can't be evicted for not being allowed to have pets. Dog barks, bothers your neighbors, you can't be evicted for that nuisance because it's all tied to COVID. The reason your mom is there is a COVID-related reason. And then the other big difference between these two is they have a couple of extra things. So the city of LA still has non-payment eviction protections, or at least we were taking the stance that it does. A lot of the other programs that had these non-payment protections in place locally were preempted by the state statute, but the city of LA tied their expiration to the expiration of the local emergency, so they didn't have to renew it. So we're saying they still have these non-payment protections. And then in the county of LA, you can't be evicted for reasonably denying a landlord entry if it's a COVID-19 precaution. So if you're worried about COVID and your landlord wants to come and do some stuff in your apartment and it's not an emergency, it's not like your tub is leaking everywhere, if you reasonably deny them because you're worried about COVID, you can't be evicted for that. So rental assistance. this is a big, exciting thing. It is the state of California. They just got a bunch more money. They are thinking they have enough money to cover 100% of everybody's back rent, which is amazing, if they can actually get the money out to people. So this is the website that you can go to apply. Your immigration status does not affect your eligibility, so everyone should apply even if you are worried about your immigration status. It's not a question. And then this is some of the requirements for income. So AMI is the area median income. It's just sort of an average. And these are the numbers that are being required for certain programs. I'm not going to go over them all, but just so you have them there, you'll get the slides after.
She asked me that question when you breakdown that one time.
Right.
And she was
okay, oops, almost done. So what can the rental assistance be used for? You can use it for 100% of your back rent from April 1st, 2020 to September 30th, 2021. You can now get 100%. That is exciting. Before it was just 75. It also no longer requires landlord participation, which the program did before. So before, if your landlord didn't want to cooperate, you could only get 25% of that rent. Now, if your landlord doesn't apply, you can still get 100% of that back rent, as long as you sign something that promises that you will give that money to your landlord within 15 days. The other big thing is that you can use this rental assistance now to pay a former landlord. That was something that you couldn't do with the old program. You could only pay a current landlord. So now if you had to move out because you couldn't afford the place and you still owe that former landlord, you can use these funds for that. Money allowing, they will also pay 100% of future rent payments, but that's not guaranteed. They're going to go through everybody with back rent and see if there's money left over to do that. And then you can also get money for utilities. So say you've been prioritizing your rent, but you've fallen behind on your electric bill, they will pay 100% of your back utilities as well. So really encourage everyone who thinks they might qualify to apply. This is the state program. Unfortunately, people in the city of LA, the city administered its own program, which has closed, and we don't have any word on it reopening. But most other places, you should be able to apply for this program. And if you can't, and you try to apply and you're supposed to apply with your local city, it'll kick you over to wherever you're supposed to apply. And yes, the landlord can also still apply first and then get the money directly, which tends to be easier. But if your landlord's not cooperative, you can get the money yourself. And finally, what if you get an eviction notice? You can contact us. If it's a short-term eviction notice, especially, I encourage people to contact Stay Housed LA. They will connect you with an eviction defense attorney in your zip code. And this, of course, is only for LA County. I'm sure there are other resources in other parts of the state as well, and legal aid organizations that will know where to send you if you call them. All right, that's it for me. I will stop sharing. Did we have any questions in the chat?
So we had one question about when the owner pays for relocation assistance. So maybe you could talk briefly about that.
Yeah, I could if I was more knowledgeable about it. I know that there are some instances in no-fault eviction cases where landlords do have to pay, I believe it's up to 1 month, equal to 1 month's rent in relocation assistance. I am not familiar with the details on exactly which of those situations that applies to. I haven't dealt with it a lot, but I can look it up certainly and get a more concrete answer for you maybe while Alana is presenting.
Sounds good. That's about as much as I know as well. So.
I saw the 100% question. Hopefully that I answered that. City of LA administered their own, and as of right now, we're sort of, up in the air on that. I just found in rent-controlled jurisdictions, substantial relocation assistance is required. So if you live in a rent-controlled unit and your jurisdiction has a rent-controlled ordinance, then it's possible that you could get even more money. So it's always good to just check your local ordinances and check in with your local legal aid orgs to see if you qualify for more relocation assistance. Okay.
I see we have a pretty specific question from Cheryl. I think that's probably a good question to call our intake line about, and we can give you a call back and provide some tailored advice regarding your.
Yeah, Cheryl, and I see you have your hand raised as well. But we're happy to, we'll provide you with our general intake line, and if you want to give us a call, we can maybe go into more detail about that, because it sounds like something that we might be able to help you with. All right, did we have anything else? Oh, what jurisdiction does Pasadena fall into? Pasadena is in the county of LA. They might be big enough that they had their, I don't think they are big enough that they had their own, or they might have opted into the state rental assistance program. Okay. Great. Well, if there's anything else, and Carrie, I'm sorry, I'm not sure what you were asking of what includes the County of Los Angeles, but if you want to specify that in the chat, I'm happy to answer. But I'm going to let Alana get going with her half so that we can move things along and respect everybody's time.
And I just see, I see one more question going back up about 25% of the total rent due. So I'm not sure specifically what that question was, but just you, well, Kate can explain, but my understanding.
Yeah, I'm sorry, I can go over it. I know it's so much information so fast. So basically, I'll give an example that is unrealistic, but it's easier for me to do math because I'm not great at math. So say your total rent from September to September was $1,000. 25% of that is $250. So you have to pay your landlord $250 by September 30th, as well as submitting your declarations, in order to be protected from eviction for non-payment for that time period. So September of 2020 to September of this year. You don't have to pay 25% of your rent every single month. On September 30th, 2021, you can hand your landlord $250 and say, I am paying this as my 25% of my total rent for this time period, and I am protected from eviction. So that's how that works. Hopefully that's a little more clear. Sorry for going over all that so fast.
That was great. I will start fair housing in 1 second. I see one more question about Pasadena, what jurisdiction it falls into. And I don't know I don't know much about the Pasadena, if it has its own renter protections or if it's under LA County.
I think they're under the counties right now. I believe last time I looked, but I can look at this actually while Alana's presenting. I don't think they renewed theirs. I think they let it lapse, but I can look. Declaration documents, the landlord will give them to you or should give them to you. You can find some of them online, but the landlord doesn't have to use a certain form. It's just certain language. And so they should be giving them to you. But for the CDC declaration, they do have, you can find them online, which I can drop a link to as well. But Alana, if you want to get going.
Yeah, I'll get going and I'll try to go through it pretty quickly so that we have some more time for questions at the end. Okay, so as Kate mentioned, we're going to be talking a little bit about fair housing protections for people with disabilities. And this is a body of law that has kind of existed for a long time, will hopefully exist for many years to come, and can be kind of used in conjunction with the COVID-specific renter protections that we just went over, or on its own. It's really a very flexible and useful body of law. when we talk about fair housing law, what we are really talking about is kind of a framework of overlapping state, federal, and sometimes local laws that prohibit discrimination in housing. At the federal level, we have the Fair Housing Act, otherwise known as the Fair Housing Amendments Act. And that protects against discrimination on kind of a core set of 7 bases. Then in California, we have laws like the Fair Employment and Housing Act and the Unruh Civil Rights Act that kind of expand the protections available to many additional protected classes. This slide kind of shows the more expansive protections available in California compared to at the federal level. You know, on the right, in the black text, you see the 7 protected categories under the Fair Housing Act. And on the right, you see in blue the additional protected classes available under California law, under both FEHA and the Unruh Act. And one thing that's worth noting is that this isn't necessarily an exclusive list. The California Supreme Court has held that, at least with respect to the Unruh Act, there may be additional kind of arbitrary bases of discrimination that would be prohibited. So one important additional area of protection that we have in California that's not available at the federal level is protection against source of income discrimination. It's unlawful to deny or limit someone's housing based on any lawful source of income. And since 2019, source of income has kind of explicitly included Section 8 vouchers and other housing subsidies. Since January 2020, it's been illegal for landlords to refuse to take Section 8 or other housing subsidies. And it can also amount to unlawful discrimination for a landlord to impose a requirement that a tenant make a certain number of times the total rent if that tenant is only paying a portion of the rent, with the greater part subsidized by a voucher. And with respect to the COVID rental assistance program, you know, initially the program was only paying 80% of the total rent due. So there was kind of an excuse for landlords to decline to participate based on not wanting to receive a lesser value than, you know, they were entitled to under the terms of their lease. Now that the program is paying for 100% of rent, it's going to be a lot harder for landlords to make that argument and not come up against potential allegations of source of income discrimination. So who must follow fair housing laws? It really applies to kind of a broad range of actors, anyone who's involved in the business of leasing or providing or managing housing. So that's anyone from a landlord or an apartment manager to a realtor to actually government agencies that are involved in the provision of housing. So public housing authorities, homeless services authorities, and many, many more. When we talk about disability protections available under fair housing law, we're talking about protections that are available you know, on the basis of a particular definition of disability. So at the federal level, there's actually a more restrictive definition of disability. At the federal level, we're talking about a substantial limitation on a major life activity. This is another area in which California has, you know, elected to provide greater protections than are available under federal law. Here, a disability for purposes of fair housing law is any limitation on a major life activity. So that's anything that makes a major life activity more difficult. And that can be working, mental, physical, and social activities, going to school, interacting with friends or colleagues. It's really a very broad and flexible definition. One thing that's worth noting is that current illegal drug use is not generally considered a disability. However, past drug addiction and current or past alcoholism can be considered disabilities. Even with respect to current illegal drug use, if the drug use is a form of self-medication or being used to mask an underlying disability, then that disability can be protected under fair housing law. Disability also includes a record or a history of disability, so a past disability that is continuing to impact a person in some way. It can also include a perceived disability. Many times people have an actual disability, but they're perceived as having a different disability or a different set of limitations. It can also include a family member's disability or a guest or an associate's disability. COVID-19 can be a disability. It can be a condition that limits a broad range of major life activities. People who have had COVID-19 may be currently limited. They may have been limited in the past in such a way that it's continuing to impact their ability to access housing. Illegal discrimination can come up in any number of different ways. COVID-19 can also exacerbate underlying or pre-existing disabilities. And health conditions that make people more vulnerable to severe COVID-19 can also be disabling. So the vulnerability to COVID-19 and the risk of infection in normal life activities can also amount to a standalone substantial limitation or limitation. When we talk about the fair and fair housing law, most of the time we're talking about the need to treat people equally, regardless of membership in a protected class. That's for most of the protected bases, such as race, color, religion, sex, and gender, etc. When we're talking about disability, we're actually often talking about the need to treat people differently in order to ensure that equal opportunity to use and enjoy housing. So that may involve creating preferential exceptions or adjustments to rules and policies. Some discrimination is intentional. It can be overt, a comment, or a decision not to rent to persons with disabilities. It can also be a policy that has a disparate impact on persons with disabilities. For example, on the earlier slide, we talked about the requirement that a tenant earn a certain number of times of the total rent. If persons with disabilities are more likely to be accessing housing choice vouchers, then such a policy can wind up having a disparate impact on persons with disabilities. A no pets allowed policy can also wind up having a disparate impact. And it's important to note that denial of a reasonable accommodation is a standalone form of unlawful discrimination. I'm just going to pause a moment because I realized I didn't plug my computer in, so I'm just going to do that quickly.
Oh no, don't want to have that die in the middle.
Yeah, okay, I think we're safe now. So what makes an accommodation reasonable? So a reasonable accommodation is any change in rules or policies or procedures that's necessary because of disability in order to provide a disabled person with equal access to housing. In addition, there's a reasonableness requirement. So the accommodation can't amount to an undue burden, a fundamental alteration, or a direct threat. So in looking at kind of the first part of the analysis, the necessity element, there has to be a connection between the accommodation requested and the limitations that are created by the disability. And again, this is really fact specific and very, very flexible. So kind of any time a disability is making it harder for a person to use and enjoy housing, then there's a possibility that a reasonable accommodation request might be made. Some common reasonable accommodation requests include waiver of a no pet rule to accommodate an assistance animal, an alternative rent due date due to receipt of disability benefits mid-month, a request to move to a quieter unit or a more accessible unit, a parking space reservation, extra time to come into compliance with the lease, or a request for a notice of termination or an eviction to be rescinded. And even after an agreement even after an eviction or after an agreement to move has been reached, a tenant can request extra time to make that move if it's necessary on the basis of their disability. The reasonable accommodation can really be requested at any time, before, during, or kind of even simultaneous with termination of the tenancy. Some examples of COVID-19 related reasonable accommodations might include a request for a live-in aid to assist with ongoing symptoms of COVID-19, someone who's self-isolating due to vulnerability to severe infection might request virtual rather than in-person inspections, and someone who's unhoused might make a request to their homeless services provider for placement in a private room if they're more vulnerable to COVID-19 when in a congregate setting. Reasonable accommodation requests, it is a process. It's not self-actuating. The tenant or housing recipient does need to initiate the process by making the request. However, once a tenant has requested the accommodation, that triggers the landlord's obligation to engage in an interactive process. A landlord can ask for verification of disability if disability is not obvious or kind of otherwise previously known to the housing provider. But if the connection is already clear, if the landlord or housing provider already has pre-existing knowledge of the requester's disability, then they're not supposed to make any intrusive requests for additional information. Again, at reasonable accommodation requests can be requested at any time, and there's no limit on the number of requests that someone can make. Each request is supposed to be evaluated based on the specific facts and circumstances in play at the time of the request. So if a landlord looks at a request and decides it's not feasible for them to grant the request, whether because it's too expensive or the landlord doesn't have the resources available to meet the request, they can't just say your request is denied. They do need to engage in an interactive process and invite discussion about alternative accommodations that could potentially address the housing recipient's disability-related needs. And any kind of any failure to reach an agreement through the interactive process is functionally equivalent to a denial of the request. In terms of verification, it's again a really a requirement that the law is has designed to make very flexible. So the kind of the gold standard for who can verify a disability is a doctor or a medical professional. These types of verifications tend to carry a lot of weight with housing providers. If the requester is able to present one. But again, that's not the only person who can verify a disability. Verification can be provided by a non-medical service agency, a peer support group, or any reliable third party who's in a position to know about the disability and more importantly, the impact of the disability on the requester's day-to-day life. So when can a reasonable accommodation be denied on the basis of being an undue burden or a fundamental alteration? So it's a very fact-specific question. The landlord really needs to kind of look at the totality of their available resources. They can't simply say it's too expensive. They need to look at kind of how much is in their discretionary funds to determine whether it's actually possible for them to grant the request. Administratively, if a landlord is kind of a small mom and pop operation, then there are some accommodations where they might say it's beyond their administrative capacity. But again, a larger management company really has to look at kind of all its available staffing to determine if there is someone available who can support the requester in realizing their accommodation. In terms of fundamental alteration, a fundamental alteration would be anything that changes the essential nature of what's on offer. So in a kind of traditional tenancy, especially in a smaller mom and pop type operation, there are kind of a range of accommodations that at least an argument could be made that an accommodation might amount to a fundamental alteration, kind of any additional supportive services that the landlord wouldn't normally provide to tenants. We see a lot in supportive housing providers, however, that many things that might be a fundamental alteration in a kind of traditional unsupported tenancy would actually not be a fundamental alteration when there are kind of dedicated staff available to kind of provide support to the tenancy. So an accommodation cannot amount to a direct threat. It's an additional basis on which a landlord or a housing provider can deny a request. But yet again, it's really a very fact-specific analysis. It needs to be based on an individualized assessment of the nature, the duration, and the severity of risk of injury, and the probability that injury will actually occur, not that it's simply possible that injury will occur. And finally, whether there are any reasonable accommodations or alternative accommodations that can be provided to reduce the threat. In general, a landlord can ask about tenant history, such as evictions, credit history, income and criminal background, but these standards have to be applied equally to all applicants, and a landlord does need to be willing to make exception where necessary on the basis of disability. And making decisions based on stereotypes rather than an individualized assessment of direct threat will generally violate the law. A reasonable modification is similar to a reasonable accommodation. It refers to a change to the physical environment of the building. The chief difference is that in most cases, the landlord is required to permit the modification, but the tenant generally has to pay for it. The exception is in some federally assisted housing, the housing provider is required to pay. And any information disclosed about disability in the course of requesting an accommodation is supposed to be kept confidential. A landlord is not supposed to share that information with other tenants. It's really supposed to be, their use of it is supposed to be limited to evaluation of the request. If you have experienced illegal discrimination, you can file a complaint with HUD, with the Department of Fair Employment and Housing, and you can also reach out to a local fair housing agency for assistance with complaint filing. And you can also call us here at MHAS for more information.
Great, thank you, Alana.
Did I stop my share?
You did stop sharing, well done.
Okay.
So I am going to launch the poll that I mentioned at the beginning. If everyone can fill it out, it really helps us out a lot with our numbers and figuring out how we're doing. So I am going to launch that right now while we maybe field some more questions. Naomi has been fielding questions in the chat, and so have I. So I think we've covered most of it, but I'm going to launch this right now. There we go. Hopefully it's going. I don't know if it's going. There we go. So it's just 5 questions, should be super quick. Anyone who can.
No, we have a question.
Sure. Someone said they have a question. Okay. Well, you can pop it in the chat or.
Hi.
Hey,
I put my question in the chat, but I was wondering what kind of federal assistance programs would be responsible for paying for the reasonable accommodations? Like Section 8?
That is a good question. I'm trying to, oh, Naomi says project-based Section 8. So maybe not a housing choice voucher, it sounds like, but project-based because they're running the actual buildings, as my understanding. All right, any direct financial assistance to landlords, not housing choice vouchers. So any federal program that's subsidizing the landlord directly, but not tied to the tenant, is my understanding. And yes, please feel free to call us. Naomi dropped our number in the chat. I think it will be on the phone number on the slides as well, and on Alana's slides, I believe. We can always pop it in the chat again if we missed it. So please feel free to contact us if you have more questions, and we will get back to you as soon as we're able. And then also, you know, we're not the only game in town. There are lots of other legal aid organizations that are also great, that you can feel free to reach out to. But we welcome you all calling us. But I just, you know, want to be sure that people know that there are lots of resources out there, and you do not have to go through whatever you're going through by yourself. So definitely feel free to reach out to us. We've got 51 of 71 folks voting so far. If anyone else hasn't started that yet and wants to get going, that would be wonderful. Everyone will be getting a copy of the PowerPoints by email. Yes, that is correct. It might not be today, but there will be a follow-up email to the presentation that will include the materials. So, and the correct materials, I already corrected my one slide that was a typo. So I'll make sure that the correct version goes out as well. We're still stuck at 51 people. Anybody else want to throw their opinions our way? We appreciate it. Oh, that got us up to 52. So I just have to nag.
I'll make a really happy face every time we get a new.
Oh, 53. Yes, and thank you everyone who has attended. I know we're bumping right up against 1 o'clock, so hopefully this was helpful. I know it was a ton of information, but hopefully at least it helps give you a basis for triggering thoughts of, you know, oh, I think I heard something about that. That might not be legal. That's our goal. We really appreciate everybody attending and everyone who's up to 58 now, folks who are filling out the survey. So we'll leave that up for another minute here until we've got everybody. But we really appreciate everyone coming, and I hope this helps you. Reach out to us and have a great rest of your day.
All right. Thank you so much.